Hello friends, my name is Lalit Soni and you are watching Polity This Week by Drishti IAS. In this episode, we'll be discussing certain topics from the polity, and these topics has been in news in past few weeks. So let's discuss them. We'll try to analyze them. We'll try to make sure that whatever is important for your examination that is covered over here. Okay, so let's start with the discussion. We'll go through these 5 topics today. One is your Article 142. Okay, this article is basically when we are talking about the Constitution is giving a specific power to Supreme Court with respect to making some kind of directions or giving some directions to the governments. Okay, so that is a power which is given in the Article 142. Then we'll be moving to the next one, that is disciplining the judges in India. Okay, when you talk about the judiciary, you know that judiciary in India is independent, and sometimes you will be feeling that judiciary has been given more power. Most of the cases, when executive commits a mistake or the legislative commits the mistake, then judiciary is there to decide. But what happens when a judge commits a mistake? Okay, professionally speaking, if a judge is giving a wrong decision, then there are provisions like appeal, or you can say review, special leave, etc. But if judge is committing any kind of mistake, let's say in the field of corruption, or you can say some kind of misbehavior, in that cases what will happen? We have always you can say read about the procedure, that is impeachment like procedure, from which a judge can be removed, but for a lesser degree of crime or lesser degree of any kind of action which has been done by a judge which is morally not right, in that case what will happen? Okay, so we will be discussing that, disciplining the judges in India. Then moving further, classical languages in India, or the classical language status which has been given to various languages since 2004. Okay, recently there was this you can say announcement by the cabinet that they will be giving classical status to 5 more languages. Okay, or when we talk about the existing classical languages, there are 6 of them, and they are adding 5 more in the list. Okay, so we'll be talking about that. We will be seeing what kind of you can say benefits are also there. Okay, then Central Bureau of Investigation, CBI. Okay, CBI has been in news for various cases recently. You know that because of the Kolkata case, and after that, when we talk about the Muda scam, when we talk about the Karnataka, wherein you can say Karnataka government has taken back the general consent. Okay, so in that case also CBI has been in news. Okay, so we'll be trying to look at certain provisions with respect to CBI. Then Enforcement Directorate, this is also an investigation body with respect to the, you can say, financial crimes which are happening. Okay, so we will be talking about the ED as well. ED has also been in news recently because of the Muda scam. Okay, you know that. So all these things we'll be discussing today. Okay, so let's start. Before that, we are having this GS Foundation course, and we are starting it soon enough from at our Lucknow center. 16th of October is the date when these courses will be commencing. At Prayagraj 3rd October 2024, Jaipur 7th October, and Karol Bagh 17th October. Okay, so when we are talking about the Prayagraj, the batch has already been commenced, so you can say admissions are open, so you can directly go to the center and get enrolled, or you can call on this number, that is 8010 440 You can call on this number for any kind of inquiry, or you can directly visit the center to get enrolled. Okay, so let's move further and start with our discussion. The first topic here is Article 142 of the Indian Constitution. Okay, recently the government has given certain kind of you can say directives when we are talking about the prisons. Okay, so in prison, if there is a caste based discrimination or any kind of provision is there which is having some kind of discriminatory actions against the, you can, with respect to some kind of caste. Okay, so in that case the court has said that government has to go for the reformation in such provisions. Okay, so that is the power which is government is having. Okay, the Supreme Court is having to make directions to the government. Okay, the Article 142 of the Indian Constitution empowers the Supreme Court to do complete justice in any matter before it. This is a unique power distinct from the court's ability to simply decide cases. It allows the court to dispense justice in a way that it ensures fairness and achieves a just outcome. So basically, in a case where Supreme Court seems that it is necessary for us to intervene or give some kind of direction to the government or any kind of executive body, in that case they can use Article 142 of the Constitution and they can direct the government, okay, in order to do the complete justice. So that is the objective, wherein you can say in the interest of justice they can give any kind of direction. Now if they are giving a direction by own on their own or suo moto, then you can say this is kind of a judicial activism, okay, which is there. But if they are actually going for it again and again, or if they start to misuse this particular power, if there is an arena where they are not supposed to speak about it, let's say if there is a you can say some kind of function which has been given to the legislature, okay, but if Supreme Court is intervening over there unnecessarily and then giving them some kind of direction, then you can say that it can convert into judicial overreach as well, okay. If they do not use this power in a just manner, then it can amount to judicial overreach, okay. If it is activism, then it is fine, but if they are not using it with respect to the you can say provisions of the Constitution, or any kind of overreach is performed, then it is called judicial overreach, okay. Now let's see when this article is used, okay. So in some special circumstances, recently there was this case wherein a student could not get the admission in IIT because of lack of the fund, and he could not actually go for submission of the fees in the stipulated time. So in that case, recently the Supreme Court has given direction to the IIT that they will be giving a seat to that particular person just because he was not able to give the fees at time. So that is why they will be taking admission of that particular person. That was a special circumstances wherein Supreme Court has intervened and Supreme Court has given this direction to the IIT. Now they have also said that if you don't have that seat in that particular department, then you have to create a seat and then get the admission done, okay. So that is the special power wherein in cases of special circumstances, in order to give the substantiative justice, then Supreme Court can intervene, okay. So Article 142 is invoked in a case where conventional legal remedies fail to achieve justice. The court uses its inherent power to address the exceptional situation, okay. So that is one thing. Coming to the next one, public interest. Court's primary concern is protecting the public interest. Article 142 is used to rectify the injustices and ensure the well-being of the society. So in case whenever you will find that there is something which is going wrong in the society, or if Supreme Court finds that they have to take a suo moto action, or if there is a PIL which has been filed in the public interest, in such cases also Supreme Court can give direction under Article 142. Now enforcement of the rights, that is but obvious when we talk about the rights of a particular person, let's say human rights, etc. In that case also they can give directions. Supreme Court can use Article 142 to enforce fundamental rights even if there are no specific laws in place. It acts as the guardian of the Constitution, okay. So basically in case of enforcement of the right in special circumstances and the public interest, they can go for the using Article 142, okay. Now what are the examples over here? One, I have told you that this IIT case, if we talk about, okay, so that was one example. That is the recent example because of which we are discussing this particular topic. Now second, if you talk about some famous cases, you know that this Sahabano case was there, okay. This Sahabano case was related to the maintenance, etc., okay. And when we talk about the, you can say, personal laws, and when personal laws are in conflict with the CRPC or the codes which we are following, okay. So in that case, Sahabano case was there, okay. The Supreme Court used Article 142 to grant alimony to Muslim woman after her divorce, setting a precedent in the Muslim personal law, okay. Now here it is a matter of right. Maintenance is a matter of right, okay. So in that case, they have taken, you can say, this particular article and they have used this article to give a direction, okay. So that is one thing. Moving further, second one, if you see Clean Ganga case, here you can say this can be a public interest example. Okay, so this can be a public interest example. Supreme Court used Article 142 to order the formation of National Ganga River Basin Authority for the rejuvenation of the river Ganga. Okay, coming to the third one, Vishakha guidelines. These are also, you can say, special circumstances wherein a law was not there and Supreme Court has given these guidelines. Until unless there is a law, you have to follow these guidelines. Supreme Court used Article 142 to lay down the guidelines for the prevention of sexual harassment of women at workplace. filing or you can say filling a legislative gap. Legislative gap means that there was no law earlier, so till the time there is a law made by the parliament, you will be following these guidelines. Okay, moving further, BCCI reforms, this is also one of the example. So this is the example where article 142 has been used properly. Now again, just if you can say, article 142 is used in special circumstances, public interest and enforcement of rights. Wherever Supreme Court feels that there is a need to do the complete justice, they can use this article to give a direction to anybody, any executive body, or you can say organs of the government. Okay, I hope that is clear. Now we can move further to the next topic. When we are talking about the before that, why is that article important? Justice beyond law. If you think, you can say sometimes laws fell shorter. Okay, let's say when we are talking about any kind of case wherein law is saying that accused, let's say juvenile justice law is there, and you can say accused is of age, that is 17 years, and let's say 11 months. So technically he should be tried under the juvenile justice law. Okay, but the thing is, since after a psychoanalysis, if you get to know that mentally this person is mature enough to be tried as an adult person, so here you can say justice beyond law. Even if there is this provision of the juvenile justice, or you can say juvenile laws are there for such people, you can say kids who are below 18 years of age, in that case also sometimes Supreme Court or the courts can go for the directions that this trial will be held as an adult. Okay, so that is justice beyond law. Sometimes law can fall short. At that point of time, the judges has to make sure that complete justice is done. Okay, Article 142 allows the Supreme Court to go beyond the rigid confines of the existing law to achieve justice in unique circumstances. Okay, moving further, social transformations. Okay, now when we talk about the social transformations, so obviously there is this existing order and you have to go beyond that particular order. Okay, if there is a law which is based on that particular, you can say social order which is already there, but now you need to change that, you need to go out of that. Okay, so then also court can use this. Okay, article 142 to bring about the positive societal changes, addressing pressing issues and upholding the human rights. Filling the gaps whenever law is silent, if there is a case wherein law is not saying anything about certain things, so Supreme Court can either put forward a guidelines that legislative has to make a law, or they can make a guideline like Vishaka guidelines that until there is a law you will follow these guidelines. Okay, so this is filling the gap in the legislative sphere. Okay, now moving further and starting with the next topic, that is disciplining the judges in India. It is a complex task. Okay, now when we talk about, you can say penalizing judges, okay, or any kind of action which is to be taken against judges, there are only, when we constitutionally speaking, there is only one thing you can do, that is impeachment, or you can say removal. Basically that would be better word, removal. Now removal can be done, Supreme Court judges removal can be done by impeachment like proceeding. Impeachment like procedure. Now impeachment itself is a big task because you have to have a political consensus for that. Why? Because the majority it requires, that is a huge majority. Okay, so basically half of the, you can say those people who are half of the total you can say membership, and 2/3 of the present and voting. Okay, so here half of the total membership and 2/3 of the present and voting. So this kind of majority is required, okay, by both the houses, and then president will remove. But there are two grounds which are mentioned in the constitution. One is misbehavior and second is incapacity. Now the problem is these words are not properly defined in the constitution, okay, and these words are quite open-ended. Okay, in that case, for a small, you can say action, or you can say immoral action which has been done by a judge, so going for impeachment cannot be the right course. Okay, in such cases, we, technically speaking, constitution does not provide you a solution to that, but in the course of action, when we talk about the Supreme Court and the other courts, they have come up with few options which are there, so we'll be talking about that. So let's see here. The Indian judicial system faces challenge in effectively disciplining judges. The constitution safeguards judicial independence but also presents obstacle to addressing the misconduct. Okay, now here you can see If we talk about the constitutional safeguards, here you can see Article 121 is there, which is prohibiting parliamentary discussion on judges' conduct except during the impeachment, okay, or except during, I would say, removal. Okay, so except during removal, you cannot discuss the judges' conduct in the parliament. Okay, so that is a safeguard which has been provided under Article 121. Then coming to Article 211, that is talking about the same thing in the cases of High Court and the state assemblies. So in the cases of state legislature also, you cannot actually go for the discussion until unless there is a proceeding for removal. Now coming to the next one, that is Article 124 Clause 4. Impeachment requires a majority of the total membership and 2/3 of the those who are present and voting. So in the impeachment or the removal proceedings, this is the majority which is required. Now it is itself is a cumbersome task when we are talking about the removal proceedings, etc. So these are the safeguards which are provided by the constitution to the judges. Now challenges to disciplining the judges, when we talk about the impeachment like proceedings, as I told you, these are cumbersome proceedings. Then what kind of challenges we are having? So here you can say high impeachment threshold. Okay, ensure judges aren't easily removed, but makes addressing misconduct that does not reach the level of the impeachment difficult. Okay, now the thing is the level of misconduct which led to the impeachment, that is, the degree is kept very high. It is made sure by the, you can say, constitution as well as the judiciary itself, that it is not easy for the judges to be removed. Okay, so that is high impeachment threshold. Now moving further to this next one, that is narrow definition of misbehavior. Now when we talk about this misbehavior, first of all, constitution does not give the definition. Second is, it covers the corruption, lack of integrity and the moral turpitude, but not indiscipline, bias or inappropriate conduct. Now when we talk about the things like biasness, talk about the things like you can say inappropriate conduct, etc. So that has not been covered under the misbehavior, because for such small things, if they start to remove judges, then it will be difficult. Okay, so for such cases, what will you do? Now real question is that for indiscipline or any kind of bias or inappropriate conduct, what is the option which is available to us? Okay, now there are few precedences. If we talk about the removal of judges, or if we talk about the you can say initiation of the impeachment procedure about the you can say judges, that is very there are very few times when such things has happened. Okay, so here you can say only 5 impeachment proceedings in history, no judge of the Supreme Court has been impeached yet. Only 5 proceedings has been initiated, but no one has been impeached. Okay, so that is how difficult it is for a judge to be removed. Okay, now what are the options which are available to us? Here you can see judicial intervention. Supreme Court can take judicial action as seen in 2017 contempt of the court case against the Justice C.S. Kernan. Okay, so in this case, what was done was that he was transferred to a different place. Sorry, in this case, he was transferred, and then there was a 6 months of, you can say, punishment or imprisonment was there. When he retired, then he was taken into custody. Okay, so here Supreme Court has intervened. Okay, so that is one thing, judicial intervention can be done. Second is transfer policy. Most of the time, to penalize the judges, they have gone for the transfer policy. Okay, if judge some kind of if a particular judge has conducted some kind of biasness or indiscipline in this particular area, so what they will do is that they will transfer that judge to a different place. Okay, so that is the transfer policy which has been used by the collegium. Okay, you know that collegium's proceedings are most of the time opaque, so we cannot say that it was just to penalize the person or there was other rationale, but most of the time it was seen that in certain cases judges has been transferred. Okay, the Supreme Court collegium can recommend transfer, which can be used a tool to discipline the judges. Okay, then in-house inquiry procedure. So courts can go for the in-house inquiry. The Chief Justice of India can request a comment from the relevant High Court, and the 3-member committee can conduct a fact-finding inquiry. Okay, so these are certain things which can be done in case of indiscipline, or you can say to try to discipline the judges. Okay, restatement of the values and the censure. Here you can say restatement of the values of judicial life, that is 1997. Here a code of justice, judicial ethics and the guide for the independent and the fair judiciary, that has been given by the Supreme Court. Okay, so this is a kind of guidelines are there, or you can say ethical conduct rule are basically there. So that is there with respect to the judges. Then censure policy, judges can be advised to resign or retire or to be assigned no judicial work if they refuse. Okay, so basically here that is the censure policy, wherein if let's say if a judge is there, he has conducted some kind of indiscipline at the end of his tenure, like 1 month before the retirement. In such cases, most of the time going for the penalizing action that can be unnecessary. So what they do is that they censure them, okay, or they will ask them to resign, or they will not give any kind of work to that particular judge. Okay, so that is the censure policy. These are certain, you can say, ways in which judiciary is trying to discipline the judges. Okay, most of the cases you will be seeing that here judiciary is doing all the jobs. When we are talking about this restatement of values of judicial life 1997, this resolution was by the Supreme Court. When we talk about the censure policy, that is, since CGI is the roast master, so he will be deciding on that. Second, when we are talking about this in-house inquiries, that is also under the Chief Justice of India. When we talk about the transfer policy, that is being done by the collegium system. When we talk about the judicial intervention, that is done by the Supreme Court. So all the cases, it is done by the judiciary only. There is no role of you can say executive or legislature. Okay, and that is how you are keeping the judiciary independent. Okay, anyways, now we can move further to the next one, the preservation of classical languages in India. Recently there was this you can say announcement by the cabinet that they will be giving a special status, or you can say classical status, to few languages. I guess 5 languages has been decided. Okay, so 5 are Pali, Prakrit, Marathi, Assamese and Bengali. These are the 5 languages which has been added, okay, in the class of classical languages. Okay, earlier we had 6 languages. So here let's see. The preservation of classical languages in India, Marathi, Pali, Prakrit, Assamese, Bengali have been accorded classical language status, expanding the recognition of India's ancient languages. Okay, India has a rich linguistic heritage with several ancient languages designated as the classical by the government. Okay, so government is deciding them. It has started in 2004, October 2004. This is not a constitutional provision or anything. This has been started by the government for the preservation of the languages. Okay, this recognition aims to preserve and promote these languages, ensuring their continued relevance to the modern era. Okay, so I hope that is clear. Now coming to the next part, wherein we'll be discussing the what kind of languages are there. Okay, so there are 6 languages which are already there. The first one was, you can say, Tamil in 2004. October 2004 was the time when they have come up with this idea, and the first language was the Tamil language. Okay, then after that in 2005 the Sanskrit was added. After that in 2008 the Telugu and Kannada was added. Then later on 2013 Malayalam was added, and the last addition was Odia. Okay, that was in 2014. But recently in 2024 Marathi, Pali, Prakrit, Assamese and Bengali, these will also be added. Okay, so ultimately you can say now we are having 11 classical languages. Okay, how do you decide whether a language is classical language or not, or how do you give this particular tag? What are the requirements or the criteria? Okay, so these are the criteria. Historical longevity. Okay, so this language should be there, or it should be an old language. Here you can say it should be having a history of at least 1500 to 2000 years. Okay, and there should be, you can say, literature to support this particular thing. Okay, esteemed literary tradition. The language must possess a body of ancient literature that is highly regarded as a cultural heritage. Okay, then originality of the tradition. This tradition should be original. It should not be taken from any other language. And the last one is the distinct from the modern form. Okay, so right now when we talk about the modern forms or the modern languages, it should be distinct from the modern forms. Okay, obviously these are the classical languages. They should be distinct from the modern languages. Okay, so these are the criteria which are there to give a status of classical language to a particular language. Okay, what are the benefits of it? So here you can see they will get academic support. Okay, so there is a Ministry of Education which will provide 2 major international awards annually for the scholars of the languages. So that is one thing, that you are getting an award for that. Second is a Center of Excellence for the Studies is established to promote the classical languages. Okay, so one is these 2 major awards, then Center of Excellence will be there. Other than that, institutional backing, if we talk about, so here you can see the University Grant Commission is required to create a dedicated professorship in the Central University. So for every such languages, let's say now if we are talking about Pali, okay, so for Pali also there will be a professorship which will be established in the central universities. Okay, so this is some kind of benefits which are there. Other than that, it helps ensure the language continued research teaching and the preservation. So if there is a continued research, if there is a continued, you can say, teaching, then only you can say preserve the language. Okay, so these are certain benefits of giving a status of classical language to a particular language. Okay, so that is about it. Now moving further to the next one, that is basically Central Bureau of Investigation in India. The Central Bureau of Investigation, CBI, in India is a premier investigation agency. It plays a critical role in maintaining law and order, and you can say combating corruption and ensuring transparency in the governance. Okay, when we talk about the CBI, there are certain kind of specific, you can say, cases which are being transferred to CBI. Okay, so if there is a, you can say, case of some kind of importance, that will be transferred to CBI. That is why we are saying that it is a premier investigating agency of center. Okay, so that is there. Now recently it was in the news because the Karnataka government has taken back the general consent. When we talk about CBI, CBI has to take a consent or the permission from the state where they want to go for the investigation. Okay, if you are asking for a case specific, you can say, consent, then you have to ask for every case, and each and every case you are going for the investigation, you have to ask for it. Okay, if the state is giving you a general consent, then you don't have to ask for the permission again and again for different cases. If you have the general consent, you can go to the state, you can investigate, and you can come back. Okay, so there are few states which has given the consent to CBI earlier, but recently Karnataka, or even there are other you can say states like Rajasthan, etc., they have withdrawn the consent. Okay, Rajasthan, West Bengal, Karnataka, they have withdrawn the you can say general consent. Now establishment and the authority. If we talk about the establishment or this particular body, where it is working and all these things we'll be discussing over here. So it is established by Ministry of Home Affairs, but it was later shifted to the Ministry of Personal, Public Grievance and the Pensions. Okay, then moving further, how it was established? It was established on the, you can say, recommendation of the Santhanam committee. Okay, so we have the Santhanam committee. On the recommendation of this particular committee, and this committee was there to prevent corruption. Okay, so on the recommendation of Santhanam committee, we have come up with the idea of CBI. Then legal basis, if we talk about what is the legal backing with to the CBI, so here you can see CBI derives its authority from the Delhi Special Police Establishment Act, that is 1946. From this particular act, they are getting their authority from. Okay, though powerful, it is neither a constitutional nor a statutory body. This is coming from a, you can say, this was formed from an executive action, and then this is you can say the legal backing which it is having, that is basically the Delhi Special Police Establishment Act. Okay, moving further, here you will be seeing the jurisdiction. If you talk about, so CBI investigation is for the various offenses which are of different nature, like bribery, corruption within the government, violation of the central law, multi-state organized crime, and the international cases. So in all these areas, CBI will have expertise and the jurisdiction. Okay, now moving further, investigating powers, if we talk about, so prior permission, as I told you, CBI requires a prior permission from the central government for the investigation involving officials at the joint secretary level and above. If the official is at the joint secretary level or above, for that you have to take a prior permission from the central government. Okay, so that is one thing. Second, Supreme Court ruling, if we talk about, so in 2014 Supreme Court decision declared that the requirement is not necessary, because this requirement is going against the Article 40. Okay, for in the eyes of law, every person is same, so why they are getting this special treatment? So that is why in 2014 Supreme Court decision declared the requirement of prior permission invalid, citing Article 14 of the Constitution. Okay, moving further, consent principle. CBI works on the consent principle. As I told you, they will be requiring a consent before entering into the state for the investigation. They will be getting a case specific consent or the general consent. Okay, so that is this one. Now moving further, here you can see revocation of the consent. If the state is revocating the general consent over here, the CBI needs specific you can say consent for the each investigation, otherwise its official lack police power in that particular state. Okay, if they do not have the consent, they will not have any kind of police power, or they cannot go for the investigation, they cannot arrest people. Okay, so that is there with respect to the CBI. We have seen the most important things from your exams point of view which can be asked. Okay, now moving further to the next one, that is talking about the Enforcement Directorate, India's economic watchdog. Okay, now with the title it is clear that economic watchdog, that means that in the economic offenses they will be taking charge. Okay, So Enforcement Director is a vital agency in India's fight against economic crimes. This presentation will be exploring the ED's role. Okay. Now when we are talking about this particular, you can say, ED, we will be talking about the its objective, its role, and which are the laws wherein ED will be having a jurisdiction. Okay, so let's see. Enforcement Director is a law enforcement agency under the Department of Revenue. Please remember that this is under the Department of Revenue, Ministry of Finance, Government of India. Okay, so it is under the Ministry of Finance. Second, it is responsible for the enforcing economic laws and combating financial crimes like money laundering and the foreign exchange violations. Okay, so we'll be looking at 3 laws which are there in the jurisdiction of the, you can say, ED, wherein if that particular law is being violated, ED will be taking charge of the case. Okay. Now, objective, if we talk about, to combat the money laundering by investigating and prosecuting the cases related to the proceeds of the crime. Okay. Second is to monitor and enforce FEMA, Foreign Exchange Management. You can say when we are talking act. So basically, this is one act which is there on which it will having the authority to go for the investigation. Okay. By tracking the suspicious financial activities in the cross-border transactions, to work in coordination with the international agencies to prevent the transaction of any kind of financial crimes or the economic offenses. Okay, so ultimately here they are trying to make sure that there is no economic offense. Okay, now coming to the laws where it will be working. So there are 3 particular laws wherein ED will be having a jurisdiction. So Foreign Exchange Management Act 1999, that is FEMA. Okay, regulates foreign exchange transactions in India, aimed at preventing illegal movement of funds and ensuring stability of the Indian rupee. So that is your FEMA. Next is PMLA, that is Prevention of Money Laundering Act 2002. So obviously it is to curb the money laundering activities, combats money laundering activities, tracing the source of the illegal funds and preventing their use in the financial terrorism and the other criminal activities. Okay. Then the third one is Fugitive Economic Offenders Act 2018, FEOA, targets individuals who have fled India after committing economic offenses, enabling the government to confiscate their assets and bring them to justice. Okay, so in cases wherein we have Vijay Mallya, okay, Nirav Modi, etc., those who has left the country. Okay, so for such economic fugitives, this law is there, and this is also having, you can say, jurisdiction under ED. Okay, so I hope that is clear. Now we have talked about 5 topics. Now there will be 5 questions for you. Then you have to answer to me in the comment box. Okay, so let's see the question number 1. What is the primary purpose of Article 142 of Indian Constitution? Option A, granting special rights to minorities. B, empowering the president to make ordinances. C, providing the Supreme Court with the power to do complete justice in any case. Allowing Parliament to amend the Constitution. Okay, so you can attempt this question and answer to me in the comment box. Now question number 2. Who appoints the judge of Supreme Court as per Article 124? Prime Minister of India, Chief Justice of India, President of India, and the Parliament of India. Okay, so you can answer that. Moving further, in which year did the Government of India introduce concept of classical languages? 2000, 2004, 2008, or 2012? Okay. Question number 4. Under which act does the CBI derive its power of investigation? The Central Vigilance Act, Delhi Special Police Establishment Act 1946, Prevention of Corruption Act 1988, Indian Penal Code 1860. Okay. Now the last question, question number 5. Which other law apart from PMLA is enforced by ED? Foreign Exchange Management Act 1999, Narcotic Drugs and Psychotropic Substance Act 1985, Companies Act 2013, Arms Act 1959. Okay, so you can attempt all these questions and answer to us in the comment box. With that, I would like to take your leave. I'll see you in the next episode. Till then, have a good day. Thank you, and please subscribe the channel.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.